Good morning, everybody, or good afternoon, or good evening, depending on when you're listening to this recording. Today's session is in relation to the impact of short-term lets on leasehold covenants. And I've used the rather groan-worthy pun of to Airbnb or not to be, but essentially this is just looking at some of the impacts of recent decisions that the courts have made in respect of leasehold covenants. And as it says there on the introduction, since around 2016, the courts have regularly found reason to find that using leasehold flats containing what we might consider as standard leasehold covenants, residential covenants, have been found to be in breach of covenant for using the property for Airbnb or short-term lets. But there's a side issue to that. Obviously I'll be looking at that, but there's a side issue about whether using the property in that way actually also converts the property from a residential use to a business use, potentially therefore breaching another covenant. And there's also an issue which came before the courts recently as to how the covenant was phrased, and whether that had an impact on the finding. And also there was a recent decision which I'll mention at the end of the session about the way in which the covenant itself is phrased, and also there's been a rather interesting decision in relation to business use in a situation which I suspect may well be replicated throughout various other lettings. And also, just as a footnote, to consider whether the ruling in Duval, which I covered in previous sessions, is going to have an impact in this field. And there is a small knock-on effect in that regard. So let's start off by giving you my details. As I said, those of you who've listened to it before will know my name's David Keighley, and I was in practice for 40 plus years until I decided I'd had enough of practicing, and I now spend my time just entirely providing lectures and seminars such as this. Anyway, enough about me. Essentially, starting off looking at the background to it. The issue is quite simple, that there is a risk of forfeiture or other action by landlords if lettings, of course, are in breach of covenant. Well, as we all know, is a matter of general leasehold law, but there is a growing body of law